You're Davius Williams, and this is 25 DCCR 0176. Mr. Williams is charged with injury to a child, elderly, or disabled individual, and what is he now?
Your Williams filed a motion case after I explained to Williams patient explaining what substitute in terms of punishment and what the state has indicated their punishment range and a motion to accumulate coming on a different trial. Immediately told me he did not want me to represent him, but I don't show his he would like to fire me.
You're court appointed, right? You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had plea bargain rejection, but let's do it again. It looks like you're charged third-degree felony, which means punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed with extraneous, but are there some that you anticipate filing?
Yes.
Mr. Smith?
Sure. Well, those are
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
So the state jail for criminally induced homicide with another state jail for attempting to take up a weapon, which is Mr. Smith mentioned. There are no other PCJ convictions.
So the third-degree felony conviction, if true, would enhance your punishment in this case if you were found guilty to the second-degree range of which.
This is where the math of criminal law quietly turns terrifying. Enhancement priors don't change the charge. They change the range. What starts as a 2 to 10-year case can instantly jump to 2 to 20 years just based on criminal history. No new facts, no new jury findings, just your past coming back into the room with you.
Is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third-degree felony was checked off instead of second-degree admonish. But I do want to make sure you understand, okay, that if you go to trial, and if that conviction for the third-degree felony, the state jails don't enhance you, or the third-degree would, to a second-degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still an offer?
That was the offer as of one.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial, and Mr. Wilkerson will prepare for trial, and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing that said indicated he has to file a motion to accumulate. He just had a 8-year stint coming into here. He was talking, he had a motion to vote for race. He shipped the office and they had up the stage on 8 years.
Okay.
We had offered to A to run for time.
Okay.
He rejects that. He will file a motion to stack whatever he receives from the jury in his case on that 8 years result.
This right here is the real leverage point, and most viewers miss it. The 4-year offer isn't just about length, it's about concurrency. Take the deal, and time runs together. Reject it, go to trial, and the state can ask to stack sentences, meaning one punishment doesn't even start until the other ends. That's how 4 years quietly becomes 12 or more.
So I want you to understand, so the third-degree conviction, is that something other than the conviction? The revocation? Or that's the one that...
The revocation is for a
the prior conviction that y'all are talking about, that third degree, that's
on the MTR.
That's on the MTRP. And so, does everyone agree that timing, though, the conviction of that?
I see what you're saying. I don't think that one does. I think the two state jail felonies won't go to.
They don't do anything. State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right. There's something that goes to you.
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance punishment because I think it has to be prior felony conviction for the date of this offense. Well, all right. I'm looking at all the lawyers. Everybody? Yeah.
Watch how carefully the judge walks this back. This isn't leniency, it's precision. Enhancement law is technical, and it must be sequential to count. Judges don't guess on this stuff. If the timing doesn't legally qualify, the court won't allow the higher range. But make no mistake, the risk is still very real.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years. States offer 4. You take your 4, you can go to trial. Mr. Wilkinson will remain your attorney. So what do you add? Okay. Well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody or going to move forward with your case, I'm clearly going to appoint you someone. You're not just going to sit in jail without a lawyer. We're going to make sure you have representation, and your case is going to move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired, and they can substitute in, and they need to get ready for trial also. Until or if that happens, if it doesn't, we're going forward. Case will be on the trial docket. We're going to move forward. We're not going to keep putting it off for that to happen. If it happens, great. But as of right now, you're rejecting the 4. Also want to make sure you understand, Mr. Smith, is there any reason to believe that offer of 4 would change?
So there's every fact we would offer to not catching it. Cover them. This belief in this case around the company time he's always right.
Okay, so I do want to make sure you understand that there's not going to be any new offers. The offer remains what it is, no matter who your lawyer is, and that there is potential for anything you get from a jury to be stacked on top of that 8 years that you already got. You understand that? Okay, we'll get it set for trial. You can go back with the bailiff. And so I am going to deny the motion to withdraw. Good morning, sir. Are you Derwin Cooley? Mr. Cooley, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. And so, Mr. Macon, will your client waive the formal reading of the motion?
Yes.
Mr. Cooley, we're going to go through this motion to revoke your community supervision and get pleas of true or not true to those allegations. In clause number F16-26460, I have a motion to revoke your community supervision. Looks like you were placed on probation January 3rd of 2023 for obstruction or retaliation, a third-degree felony, and that was a 10-year sentence that was probated for 10 years. Is that correct? Okay. I'm going to print this down. I'm just having a hard time reading on this one. It looks like count 1 alleges that you violated your probation by committing the new offense of tampering or fabricating physical evidence with intent to impair, August 9th of 2025. And is that true or not true?
It's untrue. Honor.
Mr. Cooley, I just need Mr. Cooley to plead true or not true to the allegation.
That has checked the county on the motion.
Okay.
And I believe this is referring to the risk of doubt.
Okay. We can, all right, does the state, do you want to, any objection to that amendment? Okay, so then, Mr. Cooley, so the allegation in count 1 is that you committed that offense of tampering or fabricating with physical evidence with intent to impair August 9th of 2025 in Dallas County, Texas. And is that true or not true? Count 2 alleges that you failed to report to the probation office as directed by mail for all of 2024, January, February, March, April, May, June, July, and August of 2025. And is that true or not true? Speak up. Count 3 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true? Count 4 alleges that you failed to immediately report to your probation officer that arrest for tampering or fabricating physical evidence with intent to impair. And does the state wish to amend that?
Yes, you do.
Any objection to making that Dallas County? All right, so the allegation is that you didn't report the arrest from Dallas County to your probation officer. Is that true or not true? Count 5 alleges that you possessed a drug, methamphetamine, August 9th, 2025. Should that be in Jefferson County or Dallas County?
According to Dallas County, yes.
Any objection to making that? So the allegation in count 5 is, again, that you possessed methamphetamine in Dallas County, Texas, August 9th of 2025. And is that true or not true? Count 6 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Sorry? Count 7 alleges that you were at a location other than at your residence at approximately 12:12 a.m. August 9th, 2025. And is that true or not true? Count 8 alleges that you failed to pay your court-assessed fees as directed as of August 26, 2025. You were $268 behind. Is that true or not true? Did you enter your pleas of true, counts 2 and 7, freely and voluntarily? And did you plead true to those counts because they're actually true? Alright, then I'm going to find counts 2 and 7 true, find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing where the state can bring any evidence with regard to any prior those offenses if you wish to. I need to know if you intend, I guess, on having officers, how long you expect that to take. And then we'll get it set for a hearing. I'll get an updated pre-sentence report, and we will go forward from there. All right? You can go back. We need a print. Still step in front of the clerk real quick. She needs to take it down. Person, you have John Jones. Okay, I'll hold it. Are there rejections?
204, one was considered as agreed. He's maxed out on the state jail. Mr. Coleman doesn't want to. I want to Raquel.
Okay.
And I don't know what point of not getting my max with no other. The point is, that's fine.
Okay. So do I have rejections then on the others?
Yes. Yes.
Do you have rejections? Okay. Just have a seat for a second. Let me hold this, and we'll, if you, and so you don't want to go forward with plea to the max in the state jail. So just delete that when it comes through state jail paperwork, and you don't necessarily need. If you want to do a rejection, I guess. Otherwise, I can just write it in on the other one. Okay, so you're John Jones? Just a second. Let me get your, the thing pulled up here. See, Mr. Jones, in cause number 25, DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment? And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand? Yeah. And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand? And then finally, in cause number 25, DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. You understand? Yeah. And then I have here on the tablet, in those cases, plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case, to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct? Do you understand what their offer is? And have you gone over it with Mr. Wilkerson? And do you want to reject that offer and have all 4 of your cases set for trial? Yeah. All right. Is there any reason to expect that those offers will change any evidence that you're waiting on that you guys haven't received or gone over?
Not at all. Will be more likely to be possible to the solution. The 3 of them about 1 correct, and there's 1 process.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
This is one of the most dangerous decision points in criminal court. A 35-year offer sounds massive, but compared to stacked life exposure, it's actually controlled damage. Once multiple first-degree felonies are in play, the state's power multiplies fast. Jurors don't sentence in isolation, and judges can line those sentences up back to back.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishments that you receive. Do you understand that as well? And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand? All right. And do you want to have all of your cases set for trial?
Yeah.
Yes, sir.
Yeah.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would listen. I don't know. I know the offer is what the offer is. All right. So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations and tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different purposes. All right? So you're not going to have a different offer. And that's
This is a hard truth defendants struggle with. Fairness doesn't mean equality. Two people in the same crime can receive completely different offers based on history, role, evidence, or cooperation. Courts don't negotiate by comparison charts. Your case stands on your record, and right now, that record is driving the outcome.